Hello, it's Jenkins, the family law vlogger here again. This is the next in the Stages of Divorce series. We're now near the end of the Form E and we're on section 4.5. Section 4.5 is a free style box that you can complete, which is relevant for other circumstances that you think or you think the court will think are relevant to the issues in the matter on the finances side. Remember, Form E is about the finances. So there are a few examples given in the heading to 4.5 in the Form E, which sets out the sort of things that the court's thinking about, but it really is the kind of other areas that haven't been covered already. So the obvious one and the first in the list is earning capacity. So this is talking about whether you think either you or your partner, your spouse, there are some other circumstances that maybe they're not maximising their earning capacity at the moment, but they could. For example, maybe they've got a part-time job, but they're intending to build up to full-time. Or maybe you've just started in a new profession and you're hoping to get promoted, those sorts of things. So any commentary about earning capacity would go in here. Linked to that sometimes, although not always, is disability. And that's also a section whereby this could go into this section. So it could be about the disability of children or children of the family, or it could be of you or your partner. But if the disability is relevant to the financial circumstances, then this is the section where just a few lines about that might go in here. The other areas that are listed as examples in 4.5 that sometimes come in are things like redundancy and retirement. So if, for example, you're filling in the form, but you've already been given notice that you're likely to be made redundant, or you're concerned that there might be a restructuring coming up, then that might go in here. Likewise, in relation to retirement, you might still be working full time. You might have an agreed plan or a plan that you'd like to put in place towards retirement over the forthcoming year or two. So you could put that in this section. Another area that goes in here is about inheritance prospects. Now, this can be a bit tricky because future inheritance prospects that are many, many years ahead may not carry much weight with the courts in circumstances in which we have in this country, in the UK at least, freedom of testamentary disposition. So that means that, for example, if your parents are still alive and you think you might inherit in the future, your parents are free to leave their assets to whomsoever they want. They can leave it to charity, they could leave it to another relative. They don't have to leave it to you or any siblings you may have in that example. Whereas in other European countries, for example, that's not the case. So just because you have relatives who are still alive that you think might provide for you in the event of their death, it may or may not be relevant. And so you might need some advice about whether you need to include it here. If somebody has already passed away and you know you are going to inherit under a will from somebody who's already no longer with us, but you just haven't received the funds yet, then yes, that would definitely go into this section. The other two aspects that go in here are if, for example, there's a premarital agreement or a postmarital agreement, any agreement that's been reached as to how you might deal with things during the course of the marriage in the event of divorce, that should be referenced in here. And for example, if there is a prenup, premarital agreement, then you should attach a copy of it to your Form E. And then the other final section that's often touched on in here, but we'll come to it later in the next vlog, probably on Stages of Divorce, is around any plans to remarry or cohabit or form a civil partnership. If you have formed that firm intention, or indeed if you have already entered into a new civil partnership or remarried, then that is a relevant factor the court may well want to take into account, so details should go in there. So as I say, this is quite a broad area, this box. It's an expandable box in most Forms E. There can be quite a lot to say or not very much to say at all. And as always with the vlog, if you want advice on your specific circumstances and what factors may be relevant in your circumstances and so to be put into your Form E, particularly if you're in the hands of a court, then please do get in touch with me or one of my specialist colleagues in the Mills Reeve family and children team so that we can help you with that specific advice. Thank you.